Whether the advisory opinion is wise or not, that is something I cannot comment on. Otherwise, I'll get into trouble. But it's not well thought out, that I can say clearly. And I think it will add to the confusion, rather than sort out any problem. It is confusing and messy. And really, what should be done? One doesn't know. Should the governor say that, listen, I'm bound by the directions given by the two judges, and I have to take a decision within 3 months? Or can a governor say that, listen, I'm not bound by the judgment of the Supreme Court, that'll create a constitutional crisis?
Well, in my opinion, the Supreme Court has missed the bus. Two things are important. First, that Supreme Court has not correctly interpreted the Constitution insofar as the status and role of the governor is concerned. The Supreme Court has grossly misunderstood the power of the people, namely the parliamentary democracy and the cabinet system of governance. And of course, the Supreme Court has, misunderstood, I would say, lessened its own status by saying that it has no power to issue directions to the president and the governor. So on all three counts, I would say that the Supreme Court has really given a judgment, or rather an opinion, not a judgment, but an opinion which falls far short of the expectations that one had from the Supreme Court.
Hello and welcome to a special interview for The Wire. Is the Supreme Court's advisory opinion in response to the presidential reference on how governors and the president handle legislation wise, balanced and well thought out, or does it create constitutional concerns and political problems? Second, has it subordinated an elected legislature to an unelected governor's decision-making? Those are the key issues we shall tackle today when I shall present some of the foremost legal luminaries in the country. My first guest is one of the most highly regarded former judges of the Supreme Court, Justice Madan Lokur. Justice Lokur, before I come to details, let me ask you for your overall view of the Supreme Court's advisory opinion in response to the presidential reference on how governors and the president handle legislation. In your opinion, is it wise, balanced, and well thought out, or does it create constitutional concerns and political problems?
Thank you, Karan. Whether the advisory opinion is wise or not, that is something I cannot comment on. Otherwise, I'll get into trouble. But it's not well thought out, that I can say clearly. And I think it will add to the confusion, rather than sort out any problem. The advisory opinion was preceded by a very detailed judgment delivered by two judges of the Supreme Court in a case filed by the state of Tamil Nadu. And they have looked into the entire issue of the governor's powers, what they're supposed to do when they get a bill that is being passed by the state legislature. And, the two-judge bench went into the issues raised by the Sarkaria Commission way back in the 1980s. Some issues raised by the Punchi Commission in the 1990s. And, what is actually happening, the case before them was a live issue where 10 bills passed by the state legislature in Tamil Nadu were pending consideration with the governor for months together, if not a couple of years. So it was a live issue, and it was a real issue. I mean, it was not something purely academic. But they looked into the academic aspect from the Sarkaria Commission point of view, Punchi Commission point of view. and what is actually happening in the working of the Constitution, and then they gave a decision. Now, having gone into all this, the advisory opinion, I'm not sure whether it was, the right step to have taken, either by the president or entertaining that advisory opinion by the Supreme Court. Because if the judgment was wrong, or if it was felt that the judgment was wrong, there were enough, avenues open, namely to file a review petition or to, persuade the Chief Justice to refer it to a larger bench. But anyway, the advisory opinion was asked for and it was given. But I don't think the Supreme Court really looked into the issue from a practical and pragmatic point of view, from a historical perspective, from a constitutional perspective. And in that sense, I think it was not a well thought out judgment.
You do believe it, because I think you suggested that in this answer, that the Supreme Court should not have accepted and addressed the presidential request for an advisory opinion. They should have said to the government, if you want an appeal, go ahead through the curative process. Don't seek an advisory opinion on a matter that a judgment has already settled.
Yeah. You see now, what is the situation today? The situation today is that there is a judgment given by two judges of the Supreme Court, right? It's a binding judgment. You have, on the other hand, an advisory opinion given by 5 judges of the Supreme Court, which is not a binding opinion. It's of persuasive value, but it's not binding. And it's an advice to the president. So here you have, which takes a view which is different from the 2 judges' opinion. So really, what is the law? Is the law what the 2 judges have stated, or is the law what the 5 judges have opined? Now, the Chief Justice of India, I had gone through an interview that he had given recently, maybe yesterday or day before, saying that the advisory opinion is not binding. Now, if it is not binding, okay, then clearly the judgment given by 2 judges is binding. And if that is binding, that is the law. So what does the advisory opinion actually serve?
But the truth of the matter, Justice Lokur, is now as a result of the fact that you have an April judgment saying one thing and a November advisory opinion saying virtually the opposite, you have a very messy and confused situation. Even if one argues that the April judgment is binding and the advisory is not binding, nonetheless, you have the Supreme Court having pronounced in 2 different ways, in 2 different methods on the same subject. And that's a confusing and messy situation.
Absolutely. It is confusing and messy. And really, what should be done? One doesn't know. Should the governor say that, listen, I'm bound by the directions given by the 2 judges, and I have to take a decision within 3 months? Or can a governor say that, listen, I'm not bound by the judgment of the Supreme Court, that'll create a constitutional crisis, and say that, well, I would rather follow the opinion that the Supreme Court has given to the president. I mean, it's just, confusion worse confounded.
Let's at this point, Justice Lokur, come to the constitutional concerns that arise out of the view that a timeline cannot be imposed on governors of the president. As you know better than me, state legislatures have plenary powers to legislate on subjects which are exclusively in their domain as set out by the 7th schedule of the Constitution. But if a bill passed by a state legislature in respect of such a matter is withheld by the governor or by the president interminably, doesn't that have serious implications for the country's federal structure?
It does, certainly. But, this problem is not a recent problem. And that is why I think the Supreme Court, I mean, if it had to entertain the presidential reference, it should have taken on the problem head on and, given us, a proper judgment or a proper opinion to the president. The Sarkaria Commission report, right, mentions, this is important, that between 1977 and 1985, 1,130 bills were referred to the president. Okay, under Article 200 of the Constitution. There is an annexure to this part of the report which gives as an example 15 bills that had been pending with the president for 1.5 years and more. One was pending for 12 years, some were pending for 6 years. Now, how is the state government going to run in a situation like this, where laws that are passed by the legislature, a competent legislature, I mean, there's no question about competence. A competent state legislature passes laws and nothing happens for months together. Yesterday or day before yesterday, there was a write-up in the Hindu which mentioned that, from an article that came in the mainstream of 1991, where Ramakrishna Hegde, who was one time the Chief Minister of Karnataka, he mentioned that there were so many bills that were pending with the governor or with the president for months together, right? That article mentions 58 were pending with the president for more than 1 year, 58 bills of the Karnataka legislature, right? 2 were pending for 7 years, 3 were pending for 6 years. Now, obviously, it's going to create a constitutional crisis. Federalism is, in danger in that sense, where no action is taken on bills passed by the state legislature.
There's a section of Article 200 that I want to quote you. It stipulates that the governor must handle legislation as soon as possible. Surely that implies some sort of deadline, some sort of timeline. As soon as possible can't mean that you sit on a bill for up to 7 years and 8 years.
Yeah.
So the Supreme Court has overlooked those 4 critical words, as soon as possible.
Yes, but that the words as soon as possible are in the proviso to Article 200. That is in the case of the governor wanting to withhold a bill in the sense of sending it back to the state legislature for reconsideration. He should do that as soon as possible. It's not that, I have received the bill and I'll take 1 year to make up my mind whether I should send it back to the state legislature or not. In that context, the expression as soon as possible is used. But the fact that timelines are important, whether it is as soon as possible or whether there should be a timeline, was something that was debated and discussed in the judgment of April. Right, and they said that there should be a timeline. I mean, you can't. Well, how do you say as soon as possible? It doesn't mean tomorrow. It doesn't mean day after. But there has to be an outer limit. Okay, and
that is what the April judgment sought to set, an outer limit. Correct. And that is what the Supreme Court in its advisory has undermined and deleted.
Correct, and they said there is no time limit. All right, indefinite. If it is indefinite and prolonged, then somebody can go to the Supreme Court and say that, listen, this is indefinite and prolonged. Now, what is indefinite and prolonged? I mean, if a bill is pending for 7 years, is that prolonged or is it not prolonged?
That is again where the Supreme Court, in a sense, has lapsed, because the advisory opinion does acknowledge that the governor or the president cannot hold up a bill passed by a state legislature interminably. If they sit over a bill for an unduly prolonged period, the Supreme Court advisory opinion says there is what they call a limited mandamus. But as you pointed out, the Supreme Court has failed to define what is an unreasonable delay. Correct. And that failure will not only create uncertainty, I put it to you, it will also lead to ceaseless litigation.
Yes. You see, what is unreasonable in administrative law is, would depend on each case. So, where in a statute, for example, in a law passed by Parliament, there's no time limit that has been given. The Supreme Court has interpreted, for decades, very clearly that where no time limit is given, it means within a reasonable period of time. Now, what is a reasonable period of time would depend on each case, but that's administrative law. I don't think you can apply the same principles to constitutional law. Perhaps you can take a cue from administrative law and apply that to constitutional law, but there must be some kind of a time limit. Now, if the president sends the bill back for the reconsideration of the state legislature, a time limit of 6 months is laid down. All right, there it's not indefinite or prolonged or uncertain or unreasonable or anything. So, in a situation like this, when we are talking about passage of bills, separation of powers, the principal function of a legislature to pass a law, to enact a law, we need time limits.
So you do believe, and I'm asking you this as a question, that the April judgment of the Supreme Court was perfectly right in setting a time limit. Whether that time limit should be 3 months or 5 months or 6 could be debated, but the concept of setting a time limit you do agree with.
The concept of setting a time limit, it's not only that I agree with it. Sarkaria Commission says so. Punchi Commission says so. Right? I believe, I'm not 100% sure, I believe the Justice Venkatchalaya committee, which went into the review of the working of the Constitution, also says so. Right? So there is a sort of a consensus that there should be some kind of a time limit. Now, very important. It's not only these great jurists who have said so, or these committees that have said so. The Sarkaria Commission mentions about a notification issued by the Ministry of Home Affairs in 1952, reiterated in 1978, saying that, the president or the governor should give an assent or withhold or do whatever within a time frame. And I believe the April judgment has referred to a similar sort of a notification issued in 2016, which is to say that even the government of India believes that there should be a time limit.
So in a nutshell, the April judgment was right. The advisory is mistaken, badly thought out.
Yeah.
To sum up this section of the interview, would you agree, Justice Lokur, that what the advisory does is to subordinate an elected legislature, which has plenary powers for the state list as defined by the 7th section of the Constitution, and this has been subordinated to the decision-making of a governor and perhaps even his whims and caprices?
Yes. If you interpret Article 200 in the manner in which the Supreme Court has done, that it is indefinite, and if it is indefinite, first of all, what is indefinite, one doesn't know. But anyway, assuming 6 months, 7 months, 1 year is indefinite, you are inviting the state government to litigate. I mean, is the idea to encourage litigation, or is the idea to solve problems? The Supreme Court in the advisory opinion has used the expression dialogic something or the other, dialogic expression or something, saying that there must be a dialogue between. Now, what does this judgment do? It just gives up this dialogic whatever and says that no, if there's a problem, litigate.
But it's even worse than that. By allowing the governor or the president virtually undefined, unlimited time to decide how to handle the legislation, they are also giving the governor a tactic by which he can check or chastise opposition-controlled legislatures. Because if you look at what the Times of India published on the 21st, they say as of today, 33 bills passed by opposition states are awaiting assent. 19 are from West Bengal, 10 from Karnataka, 3 from Telangana, 1 from Kerala. In each of these cases, one gets the suspicion that the governor concerned is using delay as a tactic to check or chastise opposition-controlled legislatures. And this is surely something the Supreme Court advisory should have borne in mind, but failed to do so.
Right, right, right. That's, I sort of expressed the same sentiment at the start of the interview, that look at, what is the real situation, which is something which the April judgment did. What are we going through at the moment, not academically, but in real practical terms. And if the Supreme Court had looked into that and said that, well, this is what the governor is doing, this is what the governors had been doing in the past, this is what the president had been doing in the past, and this is what eminent jurists feel, this is what the government of India feels, and we have to, look into the problem and resolve it.
And that's what the Supreme Court failed to do.
Which I think the Supreme Court, in my view, did not do.
Let's come to another aspect of the Supreme Court's advisory opinion. It's ruled against the concept of deemed assent. It says that that concept is alien to the Constitution. It says it breaches the separation of powers, which is part of the basic structure of the Constitution. How do you view the concept of deemed assent?
Okay. Now, deemed assent has also been discussed or adverted to, I think I'm again not 100% sure, in the Justice Venkachalaya committee, right? Maybe in Justice Punchi also, or Sarkaria, Justice Sarkaria, I'm not 100% sure, but it has been deliberated upon at some point of time. Now, it's a logical sequitur to a certain situation. When you say, assuming you say that 3 months is the outer limit, and it is not done within 3 months, what happens? I mean, do you just fold your hands and say, well, 3 months are over, so what? The natural consequence of that will be that, well, if you've not, given your assent, which you should have within that 3 months, or taken a decision one way or the other within 3 months, it's deemed that you have assented.
So deemed assent, as you put it, is a logical sequitur to believing that something can't be interminably delayed. If you have a timeline by which you have to do something, then the logical sequitur is, if you don't, it's deemed to have happened.
Yeah. Otherwise, now if you go on the basis of the advisory opinion, which says indefinite, now if it's indefinite, at some point of time, the court will say, all right, you do it. Okay, so then the question of a deemed assent or deemed anything, doesn't arise.
But in fact, even this is something the Supreme Court has somewhat muddied, because they've slightly contradicted themselves. They don't really believe that the president and the governor can take an undefined interminable time. They do believe it should be handled reasonably quickly, but they don't define what reasonable is, as a result of which there is no timeline, and therefore you don't know how to interpret this. So within the advice, there is an element of contradiction. They've allowed it at prima facie value to look like indefinite, but then they've added this thing that it can't be unreasonable.
Right. But then again, look at history. Sarkaria Commission talks about, bill spending for months together, years together. Ramakrishna Hegde talks about bill spending for months together.
Years.
All right. Yes, years, 6 years. Today, we are faced with a situation where bills are pending for years together. So how can you shut your eyes to it and say that, well, even though it has happened, I think it's okay,
That is the real point, isn't it, Justice Lokur, that the Supreme Court's advisory has deliberately shut its eyes to what is really happening.
Yes, to what has happened in the past and what is happening today.
And that, in a sense, is, I won't use the word unforgivable, but it's inexplicable for the Supreme Court to do.
Yes, yes, yes. I mean, but inexplicable or something which the Supreme Court should not have done. There should have been a far greater discussion and debate on the issue because it's a live issue.
You began by saying that the Supreme Court's advisory is not well thought out. It will add to the confusion.
Yes.
It actually will make the situation considerably worse because, as you said, they're encouraging state governments to litigate. They're giving the governor or the president a hidden veto by allowing them to take an unreasonable length of time because there's no time limit that's been set. So the situation could compound itself hereafter.
Yeah, yeah, yeah. The president has a veto. Okay. It said the Constitution says so that if a bill from the state legislature goes to the president for her assent or his assent, the president can say, "No, I'm not giving my assent," and that's the end of the matter. That's a closure to it. And the Sarkaria Commission does mention about bills which have not received the assent of the president. So, in that sense, there is a veto which is available with the
Now
president.
the governor, in effect, has a hidden veto because
Yeah.
he or she can take virtually as long as they want.
Yes, yes, yes. Now, again, there's a debate on that. One of the debates was what is the meaning of the word withholding in Article 200 of the Constitution? Does it mean withholding in perpetuity, like a veto or a pocket veto? Or does it mean withholding for some time till the governor sends it back to the state legislature? The advisory opinion says withholding is not absolute, it's not a veto or a pocket veto. It just means that for some time you withhold assent until you send it back to the legislature. That's one way of looking at it. All right. So they say in the advisory opinion that the governor has three options: assent, withhold by sending it back, or referring it to the president. But the Punchi Commission reads it as four options, where withholding is an option. That is, a veto is an option. So that's why all this should have been gone into.
And that's why I say they've made the situation not just messy and confused, but they've compounded it and made it much worse.
Yeah, 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 yeah.
So this is not a golden letter day for the Supreme Court.
No, I mean it's like I said, confusion worse confounded.
Justice Lokur, thank you very much for the time you've given me. I'm deeply grateful.
Yeah, thank you, Karan.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.
I'm now joined by the well-known and highly regarded lawyer and former president of the Supreme Court Bar Association, Dushyant Dave. Dushyant Dave, before I come to details, let me ask you for your overall view of the Supreme Court's advisory opinion in response to the presidential reference on how governors and the president handle legislation. In your eyes, is it wise, balanced, and well thought out, or does it create constitutional concerns and also political problems?
Well, in my opinion, the Supreme Court has missed the bus. Two things are important. First, that Supreme Court has not correctly interpreted the Constitution insofar as the status and role of the governor is concerned. The Supreme Court has grossly misunderstood the power of the people, namely the parliamentary democracy and the cabinet system of governance. And of course, the Supreme Court has, misunderstood, I would say, lessened its own status by saying that it has no power to issue directions to the president and the governor. So on all three counts, I would say that the Supreme Court has really given a judgment, or rather an opinion. It's not a judgment, but an opinion which falls far short of the expectations that one had from the Supreme Court.
Let's first come to the constitutional concerns that arise out of the view that a timeline cannot be imposed on governors or the president. Now, as you know, state legislatures have plenary powers to legislate on subjects which are exclusively within their domain, as set out by the 7th schedule of the Constitution. But if a bill passed by a state legislature in respect of such a matter is withheld by the governor or the president interminably, doesn't that create serious implications for the country's federal structure?
It does. And Karan, I think the viewers must appreciate and understand one aspect, that when the Constitution was being framed, Dr. Ambedkar and his colleagues in the drafting committee were very clear. They did not want a presidential form of the government. They wanted a parliamentary democracy. And why they chose parliamentary democracy was because they felt that parliamentary democracy was more responsible than more stable as it would be in United States of America under a presidential form of the government. So once you accept parliamentary democracy as the basis of your constitution, as basis of your democracy, then I think you have to respect the supremacy of the parliament or the state legislature and thereby the supremacy of the people. So that aspect is very important for us to understand so far as our constitution is concerned. And secondly, the constitution does not, recognize either the president or the governor as the executive head. He is a constitutional head or a formal head, and therefore he doesn't have the powers which the elected representatives possess in a parliamentary democracy. So that's something which I think we must understand, that the governor really acts only on the advice of the cabinet, and he cannot act contrary to the cabinet except in some very minor cases he has been given discretion. For example, when the bill is brought before him, which is likely to hamper with the powers of the High Court, the governor is duty bound to not accept it and refer it to the president or even send it back. So those are very limited options the governor has. If he doesn't like a bill, sometimes he feels that this is not really upholding the constitutional values, he can send it back to the legislature for reconsideration. But once they reconsider, then he is bound to approve it. But most important, the words used are in Article 200, as soon as possible. Now those words, either he assents or he, as soon as possible, he sends it back to the legislature for reconsideration or to the president for further consideration. So those words, as soon as possible, in my mind, leave no discretion to the governor to take time more than a few days or a week or two.
Quite clearly, the Supreme Court, in its advisory opinion, has either overlooked or ignored those critical words, as soon as possible, because they are permitting the governor to actually take his own sweet time.
Absolutely. And, this is the negation of democracy. I think Supreme Court's opinion will further, I would say, irresponsible conduct on the part of some of the governors, especially in opposition ruled states, as we are seeing since 2014. I mean, just look at the situation. If somebody, does not follow the constitutional norm as is expected by the ruling party at the center, take, for example, Vice President Dhankar. I mean, within no time, he was shown the door. Now, here are governors who are sitting on bills for, God knows, 1 year, 2 years. I mean, it is impossible to conceive that such behavior can be permitted under the Constitution. Secondly, it is really shocking and saddening that Supreme Court can condone such behavior.
In fact, the Supreme Court, and I'm asking you this as a question, by permitting the governor or the president to take their time handling legislation, which can be 1 year or 2 year even, they are in effect giving the governor or the president a hidden veto. And by giving that hidden veto, they are converting a parliamentary system in effect into a quasi-presidential system. That's where they completely breach the very structure of our constitution.
Absolutely right. I'll in fact read a passage from the Constituent Assembly debate when Dr. Ambedkar was explaining the role of the governor and the discretion that he has. Dr. Ambedkar said, he was responding to Mr. Kunzuru's statement. I am sorry, I do not have the draft constitution with me, except in so far as he is by or under this constitution. Those are the words. If the words were except whenever he thinks that he should exercise this power of discretion against the wishes or against the advice of the ministers, then I think the criticism made by Honorable friend Pandit Kunzuru would have been valid. The clause is a very limited clause. It says, except in so far as he is by or under this constitution. Therefore, Article 143 will have to be read in conjunction with such other articles which specifically reserve the power to governor. It is not a general clause giving the governor power to disregard the advice of his ministers in any matter in which he finds he ought to disregard. So, this is what Dr. Ambedkar wanted. Now, therefore, for Supreme Court now to say that no, the governor has a discretion is really turning this constitution upside down and really directly, according to me, take for example, today, every political party, Karan, is, fights the election on certain manifesto. If it gets elected, whether it's BJP, Congress, DMK, Mamta's party or any party, if they get elected, they want those promises which they have given in manifesto to be fulfilled so that the people who have elected them feel that yes, they have lived up to, the promises. Now they can do so only when they convert those promises into bills and enact them into laws so that they can, reach out to the people. And these people are, ordinary people. These are common man. These are poor people for whom these programs are there.
Absolutely,
Now, if the governor was, given carte blanche like this, that yes, you can, take your own sweet time and, decide to assent whenever you, get up from your slumber, then I think that very purpose of parliamentary democracy stands nullified.
Let me go one step further. There is an interpretation that the advisory opinion suggests that if the governor sends a bill back for reconsideration and the legislature returns it to him, whether it returns it altered or unaltered, he can still send it to the president, who may then indefinitely store it. Now tell me, is that a correct reading of the Constitution, or is it, in your opinion, a mistaken one?
No, governor cannot send any, bill to the president just like that. If it is within the realm of the legislative powers of the state under the constitution, read with the state list, then the governor should not really go into this area. It is not for him to decide whether the bill is constitutionally valid or not. That's in the realm of the judiciary. So governor really is left with very, very little discretion, except, as I said, that when it comes to touching the, powers of the High Court. In all other cases, all that the governor can do is to resend it to the legislature. Once legislature reconsiders and brings it back to the governor, then the story ends. The governor must approve it forthwith.
So to sum up this part of the interview, would you agree that the Supreme Court's advisory opinion has subordinated an elected legislature to an unelected governor's decision-making whims? And that is clearly not what the Constitution intended.
Absolutely. I mean, it's really, I would say it's deeply disappointing that Supreme Court is, it's not living in an ivory tower. It is seeing what's happening in the country. It is seeing that these challenges are coming essentially from, the opposition ruled states. I mean, in states which are ruled by the Bharatiya Janata Party, the governor is more than willing to give assent, sometimes as early as, in a couple of days' time. Now, Supreme Court therefore cannot be oblivious to the fact that having lost the election in a particular state, the Bharatiya Janata Party now wishes to ensure that it can control that state through the governor. And that is something which is very destructive of parliamentary democracy.
Let me build on the point you made, The Times of India on the 21st of November reported that 33 bills passed by opposition states are awaiting assent as of today. 19 are from West Bengal, 10 from Karnataka, 3 from Telangana, and 1 from Kerala. As you said, this clearly suggests that withholding assent is a tactic to either check or to chastise opposition-ruled legislatures, and the Supreme Court should have borne this in mind, but clearly did not. And it's permitted governors to use their non-existent discretion to chastise opposition-controlled legislatures, which is again a breach of the Constitution's letter and spirit.
Absolutely. In fact, Supreme Court has ignored its own judgments. In Shamsher Singh's case, way back in 1974, the Constitution bench of the Supreme Court had categorically said this, that similarly, Article 200 indicates another instance where governor may act irrespective of any advice from Council of Ministers. In such matters where governor is to exercise his discretion, he must discharge his duties to the best of the judgment. The governor is required to pursue such courses which are not detrimental to the state. This is very important. And therefore, we hold that president or governor acts on the advice of Council of Ministers with Prime Minister at the head. In case of union, Chief Minister as the head in the state, in all matters which vest in executive, whether those functions are executive or legislative in character. Neither president nor governor is to exercise executive functions personally. So, you are supposed to do it in a constitutional sense. I'll give you one example. Take, for example, money bill. The money bill cannot be brought before the Legislative Assembly unless the governor gives the assent first. Now, money bill is annual budget. Now, therefore, every state is required to have that budget, within a prescribed time, because after all, it can't be delayed even by a week or two. Now, if the governor refuses to, give assent to bring the money bill before the assembly, what happens? Will the court be powerless and not issue a direction to him? So it happened, I will tell you, in Telangana about 3-4 years ago, the then governor, a lady from Tamil Nadu, refused to, give assent to the money bill. And, a very serious constitutional crisis was likely to take place, because if the money bill is not presented and timely approved, then the state cannot, expend the monies. Salaries will have to be stopped. Everything will come to a grinding halt. And we were therefore, state was left, the chief minister spoke to me. I said, we must file a writ petition in the High Court. We filed a writ petition in the High Court. And the High Court also was in predicament. Then, Chief Justice Bhuyan, who is now in Supreme Court presiding the bench, he said that, Mr. Dave, how do we resolve this? I told him in open court very frankly. I said, Chief Justice, it is embarrassing for us as a state also to bring this to the court. But we are left with no option, and we would like to resolve it. Luckily, the governor was represented by a very fine lawyer, and we both sat during the lunch and decided that it must be resolved, and it was resolved.
Okay.
But this was a classic example where things can go really very, very bad. And for the Supreme Court to give an opinion and say that no direction can be issued to the president or the governor, I think it's really overlooking the fact that after all, governor is a servant of the Constitution.
Now, so far, Dushyant Dave, we've talked about the constitutional concerns that are raised by the Supreme Court's advisory opinion. Let's now move and talk about some of the political problems that have been created. The Supreme Court has, in its opinion, said that neither the governor nor the president can hold up a bill passed by a state legislature interminably. If they sit over a bill for an unduly prolonged period, the court says there is a limited mandamus that can be brought into play. But, and this is a very important thing, the Supreme Court failed to define what would be an unreasonable delay. Isn't this a serious lapse which will A, create uncertainty, and B, it could lead to ceaseless litigation?
Absolutely. Supreme Court should have first realized one thing, that there was a judgment which was delivered by the Supreme Court just few months earlier, after hearing all parties, including the governor and the learned attorney general appeared. The Supreme Court had, found that several acts of the governors of several states were completely unreasonable and arbitrary. And they found that undue time was taken in granting assent to various bills in state of Tamil Nadu, for example. And therefore, they issued the mandamus and said that, look, the way they have been sitting over the bills, there is therefore a deemed approval of these bills, which was an absolutely fair, correct approach to the Constitution of India and the powers of the court and the failure of the governor to act as per Constitution. Now, Supreme Court, when it was sitting on an advisory jurisdiction, should have been mindful of that judgment and should have told the government of India or president's lawyers that, madam, what is it that these governors are doing? Why, as president, you have not chided them and called upon them to act in accordance with the Constitution rather than bringing the matter before us for an opinion? Frankly, in my view, Supreme Court should have politely declined to answer the opinion, saying that you have not filed a review against that judgment. You have not gone to the curative jurisdiction against that judgment. You can't, in an indirect manner, bring this matter for opinion before us and try to, get away with that judgment. So I think the whole approach of the Supreme Court, I would respectfully say, was not conducive to judicial discipline, which is so important for the court. Court should have been mindful and respectful to the view taken by the two judges.
Let's come directly to this question of deemed assent. The Supreme Court's advisory opinion has ruled that the concept of deemed assent is alien to the Constitution. They claim that it breaches the separation of powers, which they see as part of the basic structure of the Constitution. Specifically on that point, how do you view deemed assent?
Well, first and foremost, I think it is now too well known that our Constitution is founded on theory of checks and balances. Dr. Ambedkar was very clear when he said during the Constituent Assembly debates that if there were no checks kept on each of these three organs of the state, the executive, legislature, and the judiciary, then I think chaos and anarchy would result. Now, here was a classic case where, if the governors had not acted as required by the Constitution, because the governor takes an oath to follow the Constitution, to abide by the Constitution. Now, if the governor acts unconstitutionally and completely arbitrarily, and to my mind, his inactions were clearly suffering by malice in law. I won't say malice in fact, but malice in law, because the governor was trying to achieve some other objective by delaying the assent, which was very clear because that was to help, the party at the center and ensure that party in the state fails to fulfill its promises and therefore it loses its credibility before the people. Now, in those circumstances, the theory of deemed assent has to spring into operation. Because ultimately, court could not have given a direction to the governor and said, oh, Mr. Governor, please grant your assent. Governor would have refused to follow Supreme Court's directive. It would have resulted in a constitutional impasse. Supreme Court would have had to issue a contempt notice to the governor. So rather than, take that unpleasant course, the Supreme Court chose the right path and said that there is a deemed assent. And deeming fiction is very, very common in administrative law today. So I think that deeming fiction was correctly invoked by the two-judge bench, and there was nothing wrong about it. I don't think the opinion of the five learned judges is right on that because, it's one thing is very clear. Everybody is under the law in our Constitution. And Constitution is what is known as suprema lex. It is the supreme. Secondly, everybody must exercise, whoever is being vested with powers under the Constitution or the laws must exercise those powers. And if you fail to exercise those powers, a mandamus can issue against you. So
let me ask you this then. If deemed assent doesn't exist, because that's what the Supreme Court's advisory amounts to, where does that leave the 10 Tamil Nadu laws that were deemed to have got assent and they've even been notified in the State Gazette? Where do they stand today?
Well, those bills would not have been assented to by the governor even for next 3-4 years. And the whole term we don't know what governor was doing. After all, governor has lots of time. It's not that governor has no time. Every day he goes and, goes on inaugurating something or the other from morning to evening. So if the governor's primary duty is to ensure that the state legislature functions, he is a link. Now, if his primary duty fails to discharge, then what else is to be done? Nobody knew. You can't go into the mind of the governor. that governor was going to pass the bill on 1 month after 2 years' time or 1 day after 2 years' time. Nobody knew if he is.
But can I interrupt? So where do those 10 bills stand? Because the Supreme Court advisory has struck down the concept of deemed assent, and yet those 10 bills were deemed to have got assent, and they were notified in the Gazette.
No. Supreme Court's advisory opinion does not touch that judgment. This judgment remains binding, and Supreme Court's opinion cannot override that judgment. The only way that judgment can be set at naught is by filing a review and having it set aside. And if you fail in the review, by moving a curative petition. Advisory opinion is merely advisory. It's not binding on anyone, and it certainly does not set aside or set at naught the judgment of the two judges.
My last question. I hear what you say, that the Supreme Court's advisory opinion is not a binding opinion. It doesn't set aside the April judgment. And in a sense, that was confirmed by former Chief Justice Gavai, who told The Hindu on the 24th, and I'm quoting, that an opinion given in a presidential reference cannot overrule a judgment, but only clarifies the law. But then we end up with a very strange situation. You have an April judgment which says one thing, and you have a November Supreme Court advisory opinion which says completely the opposite. This is a messy and confused situation. A judgment saying one thing, an opinion saying quite the other.
The law has been well settled for last 77 years by the Supreme Court. And right from the judgment in Ram Javaya's case and direct judgments in Samsher Singh and Nebam Rebia, the powers of the governor have been very categorically defined by the Supreme Court. So I don't think anybody has to have any doubts about it. I don't know, the 5 learned judges who gave the opinion have really not done great service to the institution by ignoring those decisions and the findings which were given in those judgments, which were binding on them.
But don't you agree that we now have a messy and confused situation, because you have an April judgment saying one thing and you have a November advisory opinion saying exactly the opposite? It's a very confused, messy situation.
No, I don't think. I mean, yes, it is a as I said, it's a side wind approach of the executive at the center to overcome the judgment of 2 judges, but they have not been able to. That judgment is binding. It's the law of the land under the Constitution by virtue of Article 141, and everybody is bound to act in aid of that judgment by virtue of Article 144. The opinion may have some relevance in future. To my mind, this opinion does not stand, in the face of earlier Supreme Court's judgments. And the position of anybody and everybody, including the president and the governor, under the Constitution of India. You are not imperium in imperio. You are bound by the Constitution, and therefore, an opinion which is now given runs completely counter to the view that Supreme Court has held and the judgments that Supreme Court has given, that everybody must act in accordance with Constitution, howsoever high you are. If you don't, we will issue a mandamus to you. They have issued mandamus against speakers. They have issued mandamus against CAGs. They have issued mandamus against governor also. So it's not that they have not issued a mandamus in the past. So this opinion, I don't know how this opinion has come about, what was argued and what the learned judges have said. But what they have really now expressed is not a law. It is neither a good law nor a binding law.
Dushyant Dave, let's leave it there. Thank you very much for the time you've given me. Take care. Stay safe.
Thank you very much, Karan.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch The Interview. Your viewership means an awful lot to me.